A man loses his case in a Delhi court. He does not appeal. He simply walks into a courtroom in Jaipur and files the very same claim against the very same person over the very same house. Somewhere else, a different dispute is still being heard. The evidence isn't even in yet, and one side quietly opens a second file on the same question in a different city. Same fight, same parties. Two different courtrooms. One law stops the second courtroom from moving at all, while the first is still speaking. Another law stops it from ever opening its mouth again, once the first has already finished. Today, we find out how the law tells these two situations apart. Introduction. This is the channel where four voices sit down with questions on law and don't get up until every corner of it has been answered. Welcome to narrator, analyst, practitioner, scholar, channel. I'm the narrator. I hold the thread, keep us moving. And ask the question that's actually sitting in the room. Three other voices are with me, and each is going to take today's law apart from a completely different angle. Let me bring them in.
I'm the scholar. And what interests me isn't just what a rule requires. It's the mischief it was built to prevent. Today we're talking about the simple civil procedural law rather than criminal law. But the underlying question is just as old. Once a dispute is in front of a court, or already settled by one, when does the law say enough? I've always found these particular doctrines quietly elegant.
I'm the practitioner. I've filed the suits, watched them get stayed, and sat on both sides of the exact question we're covering today. The scholar thinks in doctrine. I think in calendars. In clients asking me why their case hasn't even started moving. Today's topic is the reason for a lot of those delays, and also the reason a lot of bad faith litigation never gets anywhere.
And I'm the analyst. I look at procedure the way an engineer looks at a system. What's it built to stop from happening twice? Today we're taking apart Section 10 and Section 11 of the Code of Civil Procedure in India, word by word, condition by condition, explanation by explanation, nothing skipped.
Four perspectives, one conversation. In a question, civil law has spent more than a century sharpening its answer to. Once a court is seized of a matter, or has already decided it, when does the law simply refuse to let you ask again? Let's get into it. Part 1, Section 10, the doctrine of res sub judice. Analyst, let's start with the matter that's still pending. Section 10 of the CPC. What does it actually say?
Section 10 says that no court shall proceed with the trial of any suit where the matter in issue is directly and substantially the same as in a previously instituted suit between the same parties or parties claiming under them under the same title, where that earlier suit is pending in the same court, in any other court in India having jurisdiction to grant the relief claimed, in any court beyond the limits of India established or continued by the central government and having like jurisdiction or before the Supreme Court. This is the doctrine of res sub judice, literally, a matter under judicial consideration. And notice what the section does not say. It does not say the later suit is dismissed. It says the trial of the later suit is stayed until the earlier suit is decided. The explanation then adds an important clarification. The pendency of a suit in a foreign court does not prevent a court in India from trying a suit founded on the same cause of action. So, a foreign court is different from the historical category of courts beyond the limits of India referred to in the main provision. Now something about historical note. Just in case you might want to know, though it's not important, but still, I want to share that part as well. Section 10 also reflects India's constitutional evolution through a series of amendments and adaptations. Originally, the provision referred to the Governor-General in Council. That expression was substituted by the central government through the adaptation of Law's Order 1937, following the constitutional changes introduced by the Government of India Act 1935. Similarly, the section originally referred to His Majesty in Council, the Judicial Committee of the Privy Council in London, which was then the highest appellate authority for British India. After India adopted its constitution and became a republic on 26 January 1950, this reference was replaced with the Supreme Court by the adaptation of Law's Order 1950. You'll also notice that the word India was substituted for the states by the Code of Civil Procedure, Amendment Act 1951, Act 2 of 1951, with effect from 1 April 1951, aligning the language of the Code with the constitutional terminology adopted after the Constitution came into force. None of these changes altered the doctrine of res sub judice. They simply trace the constitutional journey of the Code, from the colonial era to the constitutional framework of the Republic of India.
And that restraint is the whole point of the doctrine. The object is to stop two courts of concurrent jurisdiction from trying the same fight at the same time. Not because the second court is wrong to exist, but because if both proceed, you risk two different judges reaching two different conclusions on the exact same question. That's not just inefficient, it's corrosive to what a judgment is supposed to mean. It also saves judicial time, and it protects parties from being dragged through the same fight twice at their own expense.
I've seen exactly this play out. A files a suit against B in Delhi. Before that's resolved, B, unhappy with how it's going, files a fresh suit on the same dispute in Mumbai. Now there are two suits. Section 10 exists precisely to stop the Mumbai court from racing ahead, while Delhi is still working through the same question.
Part 2. The 6 conditions that trigger Section 10. But Section 10 doesn't apply automatically. There are conditions. Analyst, walk us through them.
6 conditions, and all of them must exist together. First, there must be 2 suits, one previously instituted, one filed later. Second, and this is the most important one, the matter in issue must be directly and substantially the same in both, not just some overlapping facts. The principal question requiring adjudication has to be identical.
That distinction matters more than it sounds. If A sues B over ownership of a house, and B later sues A over ownership of the very same house, that's the same issue, and Section 10 applies. But if A first sues B to recover a loan, and later sues B again for damages arising out of negligence, the parties are identical, but the issues are not. Section 10 has no application there. Shared parties are not enough. The dispute itself has to repeat.
Third condition, the suits must be between the same parties, or people claiming through them under the same title. If a father files a suit and dies before it's resolved, and his legal heirs step in and continue litigating the same claim, that's still the same title. And Section 10 still applies, but the capacity matters. If A sues B as the owner of a property in one suit, and later sues B again, but this time as a trustee of that property, different capacity, different title, Section 10 may not apply at all, even though it's technically the same person suing.
Fifth condition, the earlier suit must still be pending. If suit 1 has already been dismissed, and suit 2 is filed afterward. There's nothing left to stay. Section 10 has no work to do. In sixth, the earlier court must be competent to grant the relief claimed. If the first suit is sitting in a small causes court, which cannot grant a declaration of title, and a second suit seeking exactly the declaration is filed elsewhere, Section 10 may not apply, because the earlier court was never equipped to give that relief in the first place.
Part 3. What actually gets stayed. So if all 6 conditions line up, what actually stops? Not the whole case.
Correct. Section 10 does not say the later suit shall be dismissed. It says no court shall proceed with the trial. That's a narrow, specific instruction. The court can still receive the plaint, issue summons, allow a written statement, frame issues, pass an interim injunction, or appoint a receiver. What it cannot do is begin or continue the actual trial until the earlier suit is decided.
And there's a very practical reason. Only the trial is frozen and nothing else. Suppose A files a suit against B over a property, and while that's pending, B starts demolishing the building. Even though Section 10 applies and the trial itself must wait, the court can still step in and grant a temporary injunction to stop the demolition. Urgent relief doesn't wait for the doctrine. Only the trial does.
And there's an explanation attached to Section 10 that closes an obvious loophole. The pendency of a suit in a foreign court does not prevent an Indian court from trying a suit founded on the same cause of action. If A files a suit in England, and later a suit on the same dispute is filed in Delhi, the Delhi court is not bound to stay its hand merely because the English proceeding exists. Indian courts are not required to wait on foreign courts the way they wait on each other.
The Supreme Court confirmed the underlying purpose in Pukharaj D. Jain versus G. Gopalakrishna, reported in All India Reporter, year 2004, Supreme Court, starting at page 3504, and published in Supreme Court Almanac Legal Report, year 2004, volume 4, page 688, and published in Supreme Court Cases, year 2004, volume 7, page 251, and published in Judgments Today, year 2004, volume 5, Supreme Court, page 329. The court held that the object of Section 10 is to avoid multiple proceedings and unnecessary harassment by staying the later suit wherever the statutory conditions are actually met, not as a discretionary courtesy.
And on that word discretionary, in case citation, Manohar Lal Chopra versus Rai Bhattacharya Rao Raja Seth Hira Lal. Published in the Official Supreme Court Reports, SCR, 1962 Supplement Volume 1, starting at page 450, and published in All India Reporter, year 1962, Supreme Court, starting at page 527, and published in Allahabad Law Journal, year 1963, starting at page 169, settles it completely. If all the conditions of Section 10 are fulfilled, the court has no discretion. It must stay the trial. Picture it this way, for a simple way to understand. Earlier suit in Delhi, later suit in Lucknow, same property, same parties, same issues. The Lucknow court cannot simply say, "I'll continue anyway." The law doesn't leave that choice open.
And the phrase, "shall not proceed with the trial," has a genuinely narrow meaning. It blocks the trial specifically, recording evidence, examining witnesses, the final hearing. Everything that happens before trial can still move forward, registering the suit, issuing summons, receiving the written statement, framing issues, granting an injunction. appointing a receiver.
In case P.P. Gupta versus East Asiatic Company, the judgment, which is published in All India Reporter, year 1960, Allahabad High Court, beginning at page 184, adds one more refinement. The court held the prohibition is against the trial of the later suit specifically. It doesn't stop the court from taking preliminary procedural steps. And if the two suits are eventually consolidated, the phrase, shall not proceed with the trial, doesn't even bar them from being heard together after that consolidation.
So picture the practical scenario one more time. A files a title suit in the Delhi District Court, claiming ownership of a house. While that's pending, B files a separate suit in Jaipur, seeking a declaration that he owns that same house. Same parties, same issue, and Delhi is a competent court. Jaipur must stay the trial, but Jaipur can still entertain the plaint, issue summons, and pass interim orders if the situation demands it. Part 4, Section 11, the Doctrine of Res Judicata. Now we move from a matter that's still pending to a matter that's already been decided. Analyst, tell us about Section 11.
Res judicata, a matter already adjudicated. Section 11 says no court shall try any suit or issue in which the matter directly and substantially in issue has already been directly and substantially in issue in a former suit between the same parties litigating under the same title in a court competent to try the later suit, and that matter has been heard and finally decided by that court. If every one of those elements exists, the later suit is simply barred.
The governing idea is disarmingly simple. No person should be vexed twice for the same cause. It gives finality to judicial decisions, prevents conflicting judgments, saves the court's time, and protects parties from being pulled back into a fight that's already been settled. A judgment that can always be reopened isn't really a judgment at all.
One caution I give every client. Section 11 does not apply if the first suit was dismissed on a technical ground. Default, a court fee defect, something procedural rather than decided on the actual merits. A res judicata only bites when the earlier court genuinely applied its mind to the substance of the dispute.
Part 5, the conditions of res judicata. Scholar, take us through the conditions for Section 10.
There must be a former suit, one that's already been decided. If A sues B for ownership of land and the court rules in A's favor, and B later files a fresh suit claiming ownership of that same land, the second suit is barred outright. The matter must also be directly and substantially in issue in both. The same distinction as before. A first suit for recovery of a loan and a second suit for damages arising from negligence, even between the same parties, doesn't trigger res judicata. Different issues entirely.
The parties must be identical or claiming through the same person. A father's suit continued by his heirs still counts. And they must be litigating under the same title, suing as owner in one case and as trustee in another can take a matter outside res judicata, even with the same person on the same side. The earlier court must have been competent to decide the matter. An incompetent court's ruling carries no res judicata weight at all. And finally, the matter must have been heard and finally decided. A decision on the actual merits, not a dismissal for default.
Part 6, the 8 explanations, where res judicata gets precise. Section 11 comes with 8 explanations that sharpen exactly where its edges sit. Scholar, analyst, practitioner, take us through all 8 explanation.
1. Former suit means whichever suit was decided first, regardless of which was filed first. If suit A is filed in January and suit B is filed in March, but B is decided before A, then B becomes the former suit for res judicata purposes. Sequence of decision, not sequence of filing.
Explanation 2. The competence of a court is judged irrespective of any right of appeal from its decision. A district court deciding a title dispute is still a competent court for res judicata purposes, even though an appeal lies to the High Court. The mere existence of an appeal route doesn't strip the original decision of its finality for this purpose.
Explanation 3. The matter must actually have been alleged by one party and denied or admitted by the other. There has to have been a real live dispute on the point. Plaintiff says, I am the owner. Defendant says, no, you are not. That's an issue. Only then can res judicata operate on it.
Explanation 4 is the one worth sitting with the longest, constructive res judicata. Any matter which might and ought to have been raised in the earlier suit is deemed to have been directly and substantially an issue in that suit, whether it actually was argued or not. You cannot split your case, arguing one ground now and saving another for later. Suppose A sues B as challenging a sale deed, arguing only fraud and loses. A cannot later file a fresh suit arguing the deed was forged. Forgery could and should have been pleaded the first time. The second suit is barred, not because forgery was decided, but because it should have been raised.
Explanation 5. Any relief that was claimed but not expressly granted is deemed to have been refused. If a plaintiff asks for possession and damages, and the court grants possession but says nothing about damages, the silence is not an oversight the plaintiff can chase later. Damages are deemed refused. A fresh suit for that same relief will not lie.
Explanation 6 covers representative suits, where people litigate in good faith for a public or common right. Everyone with an interest in that right is bound by the outcome. 5 villagers sue over a village pond. The rest of the village cannot reopen the same question afterward. Explanation 7 extends res judicata into execution proceedings themselves. If an execution court decides who owns an attached property, that same issue cannot be raised again in a later execution proceeding. In Explanation 8 covers courts of limited jurisdiction. Even a rent controller's finding on the landlord-tenant relationship binds a civil court later, because the rent controller had jurisdiction to decide that specific issue, even if it couldn't hear the wider suit.
Part 7. What the courts have said, the case law on res judicata. The doctrine doesn't live only in the text. Decades of judgments have shaped exactly how far it reaches. Take us through it.
In the case of Shamil Bhattacharjee versus State of Tripura, the judgment, which was reported in the year 2019 in Supreme Court Cases Online, Tripura High Court, Judgment Number 2, where the court held that once an issue has genuinely been decided in an earlier judgment, a later suit on the same subject matter is barred, even if it's filed by a different person, so long as that person claims through the same interest. And in another case, Shrikant Waman Pawaskar versus Deepali Dinanath Pawaskar, published in Bombay Cases Reporter, year 2019, volume 4, starting at page 129, and published in All Maharashtra Law Reporter, year 2019, volume 4, starting at page 783, and published in Maharashtra Law Journal, year 2019, volume 6, starting at page 447. The court was precise about what heard and finally decided actually means. The court must have genuinely applied its judicial mind and recorded a finding on the merits.
The doctrine's reach extends well beyond ordinary civil suits. In the case involving employers, In relation to United Commercial Bank versus Surendra Ramani, the judgment which was reported in the year 2019, Supreme Court Cases Online, Jharkhand High Court, judgment number 1118. The principle of res judication was applied to industrial disputes as well. And in Warantham Basanta Singh versus Thakcham Mangal Singh, the judgment which was reported in the year 2019, Supreme Court Cases Online, Manipur High Court, judgment number 63, where the court reinforced that the earlier decision must genuinely be on the merits and also between the same parties before res judicata can attach to it at all.
On finality, specifically in the case Randhir Singh versus Satish Kumar, the judgment which was reported in the year 2018, Supreme Court Cases Online, Delhi High Court, judgment number 9879. Court held that once the title has been decided, it cannot be reopened. And in the case of Forward Construction Company versus Prabhat Mandal, which was published in Supreme Court Cases, year 1986, Volume 1, starting at page 100, and published in All India Reporter, year 1986, Supreme Court, starting at page 391, and published in Supreme Court Almanac Legal Reports, year 1985, Volume 2, starting at page 1123, and published in Bombay Law Reporter, year 1986, Volume 88, starting at page 128. The court established that even the dismissal of an earlier writ petition can operate as res judicata against a later one, but the boundary runs the other way too, as seen in this.
Part 8. Res judicata and estoppel, where one ends and the other begins. One more distinction before we close the legal ground. Res judicata is often confused with estoppel. Scholar, where's the line?
Yes, that line let us discuss in the case Stendra Kumar versus Rajnath Dubey, which was published in the year 2016, Supreme Court, online serial number 478, and published in All India Reporter, year 2016, Supreme Court, starting at page 2231, and published in Supreme Court Almanac Legal Reports, year 2016, Volume 5, starting at page 34, and published in Supreme Court Cases, year 2016, Volume 14, starting at page 49, draws it clearly. If a later suit concerns different property or arises from a different cause of action, the court is free to decide a pure question of law differently, even against the same parties. Suppose the first suit concerns ownership of House A, and a second, unrelated suit concerns House B under an entirely different transaction. Same parties, but the court can reach an independent legal conclusion, because the underlying dispute isn't the same fight at all.
In the case Mathura Prasad Baju Jaiswal versus Dasabai N.B. Jijibhoy, which was published in Supreme Court Cases, year 1970, Volume 1, starting at page 613, and published in All India Reporter, year 1971, Supreme Court, starting at page 2355, and published in the Official Supreme Court Reports, year 1970, Volume 3, starting at page 830, and published in Supreme Court Appeals, year 1971, Volume 1, starting at page 297, makes the principle explicit. Estoppel operates against the parties, not against the court. A tenancy dispute over shop number 1 is decided later. A dispute arises over shop number 2 under a different lease. The earlier decision does not automatically bind the second, because the cause of action and the property are both different. A competent court can decide a pure question of law afresh if the circumstances genuinely justify it.
Which is the practical lesson I give clients who assume one lost case dooms every future one. It doesn't. not if the property is different and not if the cause of action is different. Res judicata closes the door on relitigating the same fight. It doesn't lock every door in the building.
Part 9. Why this architecture actually matters. So, what's actually at stake in all of this precision? Practitioner, what's your take?
From where I sit, it's years and money. Every condition we've walked through today, same issue, same parties, same title. Competent court decided on merits. Exists to stop litigants from dragging each other. And the system itself, through the same fight indefinitely. Res sub judice stops the duplication while a case is alive. Res judicata stops the resurrection once it's dead. In between them, they're the reason litigation in this country has an ending at all.
There's an old maxim behind both doctrines that it is in the interest of the state that there be an end to litigation. Not because every dispute is perfectly resolved the first time, but because a society where every decided question can always be reopened has no decided questions at all. Finality isn't the enemy of justice. It's one of the conditions justice needs in order to function.
From a systems perspective, what strikes me is how little this architecture has changed. The 6 conditions in Section 10, the 8 explanations in Section 11. This framework has survived from 1908 to today, through amendment after amendment, without its core structure being touched. That kind of endurance isn't an accident. It means the design was sound from the start.
Closing. What stays with me about Sections 10 and 11 is how carefully they distinguish a fight that's still alive from a fight that's already over. One law tells the second courtroom to wait. The other tells it there's nothing left to hear. Different moments, different remedies, but the same underlying refusal. The refusal to let the same dispute run forever.
I've stood in courtrooms arguing both sides of this. Whether a small causes court was competent to grant a declaration, whether an earlier dismissal was on the merits or on a technicality, whether a point could and should have been raised the first time. These aren't abstract questions. They decide whether a client gets a fresh hearing or gets told, politely and finally, that they've already had theirs.
What we walked through today is a system built entirely around one idea, that a dispute deserves exactly one full hearing, not an unlimited number of attempts until someone likes the outcome. That's not bureaucracy for its own sake. That's what makes a court's word actually mean something.
The man who lost in Delhi and tried again in Jaipur. The one who opened a second file while the first was still being heard. The law didn't need to guess what either of them was doing. It already had an answer waiting, one section for the fight that's still open, another for the fight that's already closed. Not every door stays open forever. And the law is very precise about which one shuts and when. Thank you for listening.